A judge issued a temporary injunction this morning, which blocks Kentucky's trigger law for now. The fight has been ongoing for about a month now, starting when the Supreme Court overturned Roe v. Wade on June 24th. Kentucky's trigger law banning almost all abortions went into effect immediately, but the ACLU filed a lawsuit on behalf of Kentucky's 2 clinics. But on June 30th, the judge sided with the EMW clinic and Planned Parenthood, pausing that ban temporarily as the judge reviewed the case. Within hours, Attorney General Daniel Cameron filed an appeal. It was rejected, so he tried taking it up to the Kentucky Supreme Court, but justices denied that too on July 5th. And today, the judge decided to extend the pause on the trigger law. WHAS 11's Bobby McSwine is here. Bobby, what does that mean right now?
Well, Shay, that means that the Kentucky only 2 abortion providers will still be able to provide abortions. They are both here in Louisville. And Judge Mitch Perry's decision rests on these factors: violation of the right of privacy and self-determination, the right to equal protection, the right to religious freedom, and the opinion that the proposed anti-abortion laws are unconstitutional and vague. Despite the ruling, both sides say the fight is far from over.
After a month of legal battles, a 20-page opinion granting a stay of a temporary injunction allowing abortions to continue in Kentucky. The ongoing fight has been the subject of several recent protests across the state.
Our legal team has been working essentially around the clock to ensure that our clients are able to continue to provide care to the people of Kentucky.
The ACLU praising Jefferson Circuit Court Judge Mitch Perry's decision on Friday, while the pro-life group, the Family Foundation, immediately rebuking his ruling.
It's an absurd act of judicial activism at the state level. It has long been the intent and will of Kentuckians and the General Assembly to protect life in the womb.
Judge Perry writes that the plaintiff, EMW Women's Surgical Center, demonstrated it would suffer, quote, irreparable harm without injunctive relief, citing the 200 patients the clinic had to turn away between when the Supreme Court overturned Roe v. Wade and when the temporary restraining order was granted. He also writes, quote, abortion is a form of health care, and that, quote, the inquiry does not end simply because the word abortion is not found in the Kentucky Constitution. It's a point the Family Foundation pushes back on.
It's absurd to think that there's been this secret right to abortion within the Kentucky Constitution, despite the Commonwealth's 150-year-long pro-life history.
The ACLU says though the landscape is ever changing, they hope Kentuckians are encouraged.
Granting the injunction today gives us hope that he believes we do have a strong case, and we will continue to fight.
Now, while both sides expect a continuing legal battle, they also both look ahead to November. Kentuckians will be able to vote yes or no on a constitutional amendment that will guarantee that there is no right to an abortion in the state. I'm live in the newsroom. Bobby McSwine, WHAS 11 on your side.